This is Earl White, real estate attorney. This is a video about a certificate of occupancy requirement contract provision. We're going to address what is a certificate of occupancy, what is the contract provision, and what are three critical considerations that the buyers and sellers of real estate should understand when negotiating this contract provision. First, what is a certificate of occupancy? A certificate of occupancy is a government certificate that's typically in writing, that's issued after a building inspector from a zoning department, a building department, whatever that city calls it, that will come out and the inspector will look for code compliance, such as missing permits, closing open permits, open or closed code violations, and safety and habitability concerns, such as railings, structural problems, anything that would impact the safety for the occupant moving in. So once the city inspector completes that, he issues the certificate, and that certificate would typically be required for either transfer of title. So you need it to legally transfer title to the new owner, or you might need it legally for either the buyer or a tenant or some other occupant to live there. So you need the certificate first. So that's what certificate of occupancy is. Now, what is the contract provision about this? The contract provision for a certificate of occupancy places the responsibility on either the buyer or the seller to obtain the certificate from the local city. This typically would include responsibility for applying for the city. We typically submit paperwork to the local building department or zoning department, which would request typically some fee like $200, and also request that a city inspector come out and inspect the property. So you submit the application, then the responsible party would then typically attend the inspection to see what the concerns are raised by the code inspector, and then that party that's responsible would then work on curing whatever issues came up during the inspection, scheduling the reinspection to get the certificate, and again, rinse and repeat if there's still issues, then cure those issues. So the contract provision makes the responsibility of the party, of either the buyer or seller, to handle this process, and obviously to get the certificate and deliver it to the closing. So three important considerations when drafting and negotiating these contract provisions. First is who is going to be responsible for who's going to be responsible for getting the certificate. The seller, on the one hand, is more often than not responsible. The reason they're responsible is because they're the owner, so they have the one with the right to make modifications to the property. It makes sense for the owner because most likely the issue that arose to cause this initial inspection to fail, if one did happen to fail, occurred during their watch while they were the owner, right? It's not the buyer's fault that it failed. And then also the owner has easier access as the owner, so they can get in and schedule things easier than the buyer, who has potentially no access to the property, trying to schedule everything. So that can be really problematic. The buyer may be responsible for the certificate of occupancy in a situation where they're a sophisticated party. Perhaps they flip houses. Perhaps they are general contractors, or they have some significant experience in real estate, in which case they may actually prefer to handle it because they may want to modify the property how they see fit, and they just can do it either faster or cheaper than the seller. So if the sophisticated buyer, that may be a case where they handle it, or it may be the case the buyer handles it if this is an estate sale or the owner is far away, where the owner has limited involvement with the property and has had limited involvement with the property. So the deal from the beginning is the buyer to handle any government certificates. So another important consideration when you're drafting these provisions is a financial limit on the party that's responsible their liability, right? Because you don't know what the issues raised by the city inspector are until they come out and do the inspection. So if we're in a contract drafting phase in the beginning of the process, we wouldn't want our buyer client or seller client to be on the hook for an unknown amount of financial responsibility. So for the seller side, why would the buyer want the seller? Why would the buyer want the seller to have no limit on responsibility? Obviously, they would rather not handle some costs on their own, so they would want the seller to handle it. But from the seller's perspective, they may say, look, we're not going to take indefinite liability for costs to get a CO for two reasons. One, it's indefinite, so they don't even know what they'd be signing up for. And then two, if there is a lot of repairs and modifications and improvements required to get the certificate, then the buyer, when they take ownership, would benefit from those improvements. So, if they have to install, if the hot water heater is old and it didn't get a permit and they have to install a brand new one, well, if it was old, the buyer understood it was old and most likely had to be replaced. Now the seller has to bear that cost. It doesn't make a lot of sense. So there may be a limit for the seller to handle these issues because the buyer may be getting a substantial windfall by getting all these upgrades or potential upgrades at the property. Now, as the buyer, you would also want a limit. If you're handling it, obviously you want a limit for the same reason as this unknown amount of liability. And again, you didn't create the issue, so why should you be responsible? So that's the negotiation piece for what the financial limit should be. What is the limit? It's negotiable between the parties. Sometimes there is no limit and the seller just has to, or buyer, I guess, just has to do it. And that is what it is, regardless of cost. Other time, but the number is negotiable. So you could see $5,000, $2,500, $500, depending on the market. So really it's a negotiable on the amount if there is one. Last important consideration is a closing with not a full certificate of occupancy, or they could be called certificate of compliance, certificates of habitability. They take a million different variations for the name. So if you see those terms, that also refers to certificate of occupancy. So for the conditional certificate of occupancy, which may be referred as to a temporary or conditional certificate of occupancy, or like I said, temporary conditional approval, or just called sometimes a certificate of transfer title, they might call it. And that is a certificate that's issued by the municipality with a list of conditions that must be remediated following the closing. And typically there are a few features of this temporary certificate. One, obviously a list of items that have to be remediated. Two, a time frame for the remediation of the issues to occur. And also, these certificates often will have a requirement that the property cannot be occupied, or the property cannot be occupied by the buyer or any tenants or any occupants until all the conditions in the temporary conditional certificate of occupancy are cured, and then the property can either be leased or moved into by the buyer. Obviously, the buyer would not want to take a temporary CO because there can be penalties that obviously you have these timeframes and these repairs, and some cities will attach penalties if these items are not resolved in the appropriate time frame. If the buyer closes with a temporary certificate of occupancy, then it is also not uncommon, if it was the seller's responsibility in the first place, to have a post-closing escrow agreement, which places the responsibility of the post-closing repairs onto the seller. So seller's going to be responsible. And then money will be held aside, typically 150% or some other percentage of the amount of the cost to repair the items in the list. So that money will be set aside, perhaps held by a title company, held by attorney, only to be released to the seller upon issuance, the completion of the repairs and issuance of the full certificate of occupancy.